Hi, everybody. It's Melanie at Minnesota Title, and today I have with me Morgan Kavanaugh, and he is the managing partner of the Edina real estate law firm Wilkerson and Hegna. He focuses his practice in areas of real estate and business transactions, commercial litigation, and advising closely held businesses and individuals. So Morgan graduated magna cum laude from William Mitchell College of Law and has a BA from the University of Minnesota. In addition, Morgan is an adjunct professor at Mitchell Hamlin Law School, serves on the West St. Paul Planning Commission, and is vice chair of the Dakota County Special Board of Adjustments and Appeals. In 2020, Morgan's practice has focused on land deals and acquisitions, new home construction, commercial leasing, development, and contract workouts. So I invited Morgan with us today so that he can help all of you understand some of the things that he has to deal with. So Morgan, you often get calls from buyers and sellers after closing when there's a problem with a property. What should a buyer and seller know about the disclosure requirements and legal issues that can arise in buying or selling?
Yeah, well, first of all, thanks for the introduction, Melanie. Good to see you, and thanks for having me today. Happy New Year to everyone. This is a good question because I get a lot of calls on this topic from both buyers and sellers, and it's a very stressful time for people when they feel like they've just closed on a transaction that was a positive thing in their life. Things are great. They're moving into the house. And when you're on the buyer's side, you just want to enjoy your new house. You want to settle in and start living your life at your new forever home, or for whatever reason you're there. And so when there's a problem that arises with the house, it causes a lot of stress and anxiety for people. So I get a lot of calls from people that are in a panic that something bad has happened at the property. And it can vary from minor issues to really extensive problems that really disrupt people's life. So the questions I get from a buyer who's closed, what can I do? What are my remedies? Can I go after the seller? What do I have to do to recover from the seller? Questions like that. And so I have to explain a lot, the basics of the law in Minnesota, which might not always be understood by people. I think there's a perception that nothing will go wrong with the house after closing. It's going to work perfectly and for many years, and you shouldn't have any issues or hassles to deal with. And that's not necessarily the case. Now, there are new home construction warranties if you're buying new home construction that come into play. And so there's certain protections if you're buying new construction, and that's a whole different topic for another time. But if it's not new home construction, you're not getting warranties unless you specifically get them from the seller, which you're not going to get in the standard forms. And unless you buy the specific warranty packages for some of the things in your home that you can get that have coverage, like the furnace or refrigerator or any of those types of things, you can buy a specific warranty product. But from the seller, what you're getting from the seller is that they're being truthful and forthright and disclosing all material facts that they know about the property. And that's a tricky thing to come back later and show that they did not disclose all material facts, that they had knowledge. It has to be an actual knowledge of these issues that they failed to disclose. So a lot of times, there's a couple different dynamics going on. You'll have, when there's a cover up or actual fraud of a serious problem at a property, that's a little bit more clear, that you have some evidence that shows they knew of a major issue and they concealed it in some way, or neighbors were aware of this major problem that they just covered up and papered over, and then all of a sudden it rears itself after you buy the property. A lot of the calls I get are this sort of gray area of they didn't fully disclose these issues that they knew about. Well, how do you know they knew about them? Well, they must have known, and that's not enough. We have to talk about that a lot with buyers, that they need more than that. And there's also the issue of, you get the disclosure from the seller, that long form that they fill out that contains a lot of information. Yeah. And you're reading that, there might be some things in there that they downplay a little bit, try to massage to try to not look as bad. So you might have an issue that arises with the foundation, but maybe on the disclosure, they did put some cracking and some issues, and they don't really get into the full extent of it. Well, when you come back later to argue they didn't fully disclose this, they're going to say, well, no, we did. It's on the disclosure form.
Mm-hmm.
So all these things come up that you have to think about and work through, and an attorney can help with that. The other big thing that comes up is that the perception from a buyer that you can get the cost of repair. So let's say you can show clearly that the seller knew of something, failed to disclose it on the disclosure form. And a lot of times you'll get somebody that says, well, now it's going to cost me $40,000 to fix up this basement, to fix this issue so that it's, how I expected it or wanted it to be. And I have a contractor's bid that is for $40,000 to do this work. Now I should be given $40,000. And that's the wrong approach in Minnesota. We use what's called the out-of-pocket loss rule, which kind of doesn't make any sense. But what the case law says is what they actually look at is the difference in price in the market value, or the value that you paid for the property. And you get the difference between what you paid and what you should have paid had the issue been fully disclosed to you as the buyer. So that requires an expert appraiser to come in and say, assuming this issue, you prevail on the issue of that this was not disclosed to you, and they're in the wrong. You would, let's say the purchase price that you paid was $320,000. If this had been disclosed to you, the market would have paid $300,000. So your damages are $20,000 in that case, not the cost of repair. You have to be able to prove that. Sometimes, in a lot of cases, you can sort of line those things up that, these expert appraisers or somebody else with knowledge of how to value real estate will be able to say, it's close. The cost of repair and the difference in market value is pretty similar. So you can sort of use those and interplay those things to justify the other. But you shouldn't just rely on the cost of repair. So thing to think about for buyers. So the biggest thing is, when you get into all these non-disclosure disputes where something wasn't disclosed to a buyer, and now there's some discussion back and forth or arguments about what the seller has to pay the buyer to compensate them for their issues. It just goes back to, the beginning of the process. When you're looking at buying a property, what should you do to protect yourself? And the best way to protect yourself is to get an inspection that's done well and that's very thorough. And that's skipped and ignored a lot of times because it costs money, like a good in-depth inspection. And not one that just sort of looked at the property, but one that really goes into specific areas with different experts, a chimney expert and a foundation expert, and somebody to come in and provide different opinions on the different parts of the property. It's going to cost a lot of money, but sometimes it's worth it to spend a little bit of money to save a lot of hassle later. Right. And that's because people fall in love with the house, right? And they like the neighborhood, and this is the one. They don't want anything to disrupt that, but that's probably the best way to avoid these issues, is to protect yourself up front. And then you have an inspection report, and it's sort of a double-edged sword. And if you get an inspection report and then later have a non-disclosure issue, the case law also seems to indicate that you're relying on that inspection report, not necessarily the disclosure from the seller. So that's why you want your inspector to be top-notch and good quality.
Do you work yourself with certain inspectors that you would recommend because they do a good job?
Not necessarily. I mean, what we would be working with are the folks that come in once there is a big case and dispute that are trying to recreate the situation. Realtors and brokers are well attuned to who they would recommend. So if you have someone that you're working with, a realtor or a broker, to get their advice on who they see is out there, because dealing with. And if you trust your realtor or broker, you should trust their recommendations when it comes to that, because they're the ones out in the world dealing with these people.
Yeah.
And you're hoping you get someone you trust, and those referrals are important. From if you're dealing with someone you trust, then you're getting somebody that they trust too.
I agree. So what happens when the deal goes bad before the closing? How does the seller protect themselves, and how could a buyer get out of a deal and keep their earnest money? Does that ever happen? How does that happen?
Yeah, that can pop up from time to time. So we'll get calls from both sides. Somebody, expecting to close on a deal, and they get a call saying that the buyer's not closing anymore, can't close. Very frustrating, obviously, when you have everything lined up ready to go, and they might have a purchase lined up ready to go. And so then the seller's going to have some damages, out of pocket costs and things that they need to figure out a way to recoup that. So that's where the earnest money comes in as a big piece of the deal. And it's sort of overlooked as just kind of a minor thing. It doesn't really matter what the earnest money amount is, $1,000, minimal amount. But from the seller side, you want that amount to be, on the higher end. I think the industry standard is 1% to 3% of the purchase price. So if you can get that negotiated to get, on the 3% side, you'll have more protection if the buyer decides to walk away from the deal. And that's essentially your recourse when you're a seller. You can't force the buyer to come up with the money to buy the property, force them to sell the property or to buy the property. Your remedy and recourse is to keep the earnest money, and then move forward and try to find another buyer. So what you have to do if that happens to keep the earnest money, there's a statute in Minnesota, and I don't need to get in necessarily. I have, the books over here, but I don't need to get into the weeds on that. But it's Minnesota statute 559.21 and 0.217. There's some procedures in there that, realtors and their clients should be aware of, in terms of it's not a simple just send a letter out. It's if they're not cooperating, if they're not agreeing to give you the earnest money as the seller, then you have a dispute. And a lot of times these get worked out. There might be a split in the earnest money or something else to allow the party, and a mutual cancellation. That's obviously ideal. If everyone can control their destiny, keep their costs down, not have to pay an attorney, go through all the hassle of this. If you can reach an agreement, and realtors will work hard to try to do that, where the parties can agree to mutually cancel the purchase agreement, whatever the split of the earnest money is from there. But if there's just, parties are entrenched in their positions, there's a statutory form to serve personally on the other side, as you would a lawsuit. So you have to make sure the form is done right, and you have to give it to a third party. And we use a company called Metro Legal Services for service of these types of legal documents. They find the buyer, and they personally hand them the legal paperwork that says, we're canceling this purchase agreement and we're keeping your earnest money. And then from there, the buyers have the opportunity to decide what they want to do. If they if they want to dispute that the seller gets to keep the earnest money, they have to then serve their own cancellation back the other way in the same manner. Once that's done, the earnest money is sort of up in the air, and the parties can go to court and argue about who gets the earnest money. But they also can go right to court and say, no, you don't get to cancel the purchase agreement. It's not canceled. I can still perform, and get essentially a restraining order from that cancellation becoming effective. So there's a lot that kind of goes into it, in different dynamics that happen. But the biggest things that folks should be aware of is that it's a 15-day window. So it's a very short period of time. So if you're the buyer and you want to, save the deal, or if you think that you can still close on it, you just got to make sure you act quickly. You're on the seller side, you just have to be aware. You have to do these steps. You have to cancel the purchase agreement before you can relist the property again. You can't have open purchase agreement. Even if you know that they're in the wrong and they breached and they're the ones who didn't close on the deal, you still have to cancel that purchase agreement so you can relist the property, or the title is clouded. So those are the things, kind of the main things to be aware of. I think on the when you're on the side of the buyer, the big thing that trips people up that I see often is the clause in the purchase agreement that's regarding the financing, the written statement. There's a clause in there that talks about delivery of the written statement. And so I just encourage everyone to look at that, read that carefully. It comes up all the time where if you're on the buyer side and you did not deliver this written statement that you've been approved for financing, then the purchase agreement can be canceled and you get to keep the earnest money. And so you might get to a point where everyone thinks the deal is moving forward to closing, that the financing is ready to go. And then for some reason, the folks lose their job or something else happens where they don't want to close anymore, but they never delivered that written statement so they can still get out of the deal. So once their loan is approved, they have the loan approval letter, that you get that as the seller. You get that on the date that they agreed to give it to you. And then they're locked in, and then it's you're a lot better position in that time period from when they get that approval until closing, which could be 2-3 weeks. And then you're much more protected. You got the written statement, says they're approved. They can't use that as a reason to get out of the deal.
Right, that makes sense. Another hot topic that's often asked about is arbitration clauses in purchase agreements. So what's your opinion about agreeing or not when it comes to arbitration disputes?
Arbitration is interesting. There's a lot of different opinions about it. So this is just my opinion, and you'll talk to other people, other realtors, brokers, other attorneys that might have a different take on it. And it's not necessarily wrong. It's just different things to think about. So I think the most important thing is it's something that you should be thinking about and asking about. And it might depend on your situation. And so don't just willy-nilly reject it, and don't just willy-nilly agree to it for sure. Some things to take into consideration with arbitration. The big selling point in arbitration is that it costs less and it's a quicker process. So those are the sort of the positives of arbitration in general, is that it costs less than going to court because the requirements and the rules and the processes you have to go through are less formal and stringent than you do going to court. The downsides are, though, is that it's called arbitration, right? It's arbitrary. You get an arbitrator who's, generally an educated, experienced person, but they're not a judge. They're not accountable to the people that way. They're not part of that judicial code and process that our judges are. So they don't necessarily need to make a decision that follows the law. They can make an arbitrary decision and not even justify why. And you will typically get reasoning from the arbitrator, but you might not. And you really can't attack their reasoning unless they're biased. There's these really narrow things you can do if you get a decision that you don't like. So you're limited in your rights in arbitration, in that once an arbitration decision is made, it's final. You can't appeal it to district court. You don't get to go to the Court of Appeals unless it's on very narrow grounds, like I said, in these extreme circumstances. Where in court, you get all the protections of the rules and case law and statutes, and you have a right to an appeal to the Court of Appeals. All these different mechanisms are there to protect you when you're in court. So those are the things you're kind of weighing between arbitration or not. I believe that when you're on the seller's side, that you will want court protections. So you should reject the arbitration clause when you're a seller, is my opinion. Because if you sell, you don't want to be drugged into a process that is quick and arbitrary, where you might have to pay out to the buyer. You want to be able to protect yourself and defend yourself and have all the protections that court affords, and just understand that there's risk in selling real estate, that you might have a potential claim, and the way you protect yourself is fully disclosing everything you know and all that good stuff. But if there is a dispute that arises after closing from the seller side, you don't want there to be a quick process. When you're on the defense side, generally in litigation, you kind of want to grind the wheels of justice to as slow as you can. Want to wear the other side down, is kind of the concept. So you don't want to be writing a big check, quickly.
Right.
And so then the flip side of that is then a buyer. If you're on the buyer side, you're going to be in a position of you want a quick resolution to your problem. You have something going on at the property, some issues happening that are causing angst and stress in your life, and you want results. You want a resolution. You want to pursue justice as quickly and efficiently as possible. So you'll want arbitration as the buyer, and it's going to be a quicker, cheaper process for you on the buyer side, because what you need in a lot of these cases, and in both arbitration and in court, you can't just go in there and shoot from the hip and testify just on your own. You need experts, and if there are issues happening with the property, and especially like the valuation stuff we talked about, the out-of-pocket loss analysis, you're going to need to bring somebody in to talk about that. And that's going to be an additional cost in litigation. In arbitration, there'll be some cost too, but because it's a quicker and a more efficient process, and they won't get bogged down and requiring all these different reports and things you need to do in litigation, they can just kind of show up and testify, and you can do it a lot cheaper than you could in litigation. So you'll be able to get a decision, and potentially it might be in your favor, and you'll get an award. And once you get that award in arbitration, you just go to district court and it becomes a judgment. And so you have the opportunity to collect on that way quicker than if you had to go through litigation, which can take 12, 24 months. You have to keep that in mind. So that's my kind of quick take on, should I agree to an arbitration clause or not? And if I'm on the seller side, I'm rejecting it. If I'm on the buyer side, I'm going to try to push for the arbitration.
Now, if there's an agent out there that maybe is dealing with a client that could use your advice on something, do you accept just a phone call? Can someone just call you and ask you quick questions? Do you set an appointment? How does somebody get a hold of you or meet with you if they need your services?
Yeah, I get calls all the time, just cold calls from somebody who I've worked with in the past, referred someone to me that's dealing with something like this. Or emails are great too. So I might get an email from the realtor or broker saying, we've come across this issue, or somebody's looking for some legal advice on an issue they're facing. Can we schedule a time to chat with you? And I'm always happy to do a free initial consultation to see what's going on, to see if we can help. And, maybe it's something that, the party should just be able to work out, or the dollars in dispute aren't, high enough to make sense for somebody to pay an attorney to get involved. But I'm always happy to at least guide them and send them in the right direction. And then if it's a bigger issue or something that, needs immediate legal assistance, we can jump in pretty quickly.
Awesome. Well, it was so great chatting with you and learning all of this stuff.
Yeah, thanks for having me.
Yeah, we'll have to do this again sometime, or maybe do a little mini class, because I think the information that you have is really valuable. And especially, for real estate agents that are really unfamiliar with some things that can happen, maybe people newer in the industry too, it's good to get ahead of the game and understand some of this stuff. So awesome.
Yeah, absolutely. Yeah, I'm happy to talk about these things, and I deal with them on a daily basis, where, I think in a lot of places you're closing deals, it's a positive thing. There's not these things that pop up often.
Yeah.
And when they do, you just got to be careful that you're not giving incorrect direction to people.
Right. And even just having somebody like you that they can refer them to get their questions answered, I think is great too. Well, thank you so much. Have a great rest of your day, and we'll do this again soon.
Great. Thank you.
All right. Bye.